all for staying on. We have an absolutely terrific panel next, and I think it will be made all the more appealing by the fact that it's going to be very brief. We only have about an hour. The topic is the devolution of immigration and immigrant integration policy to the state and local governments, and I think we all know that we all are familiar with the demographic context within which these policy developments and devolution more broadly are taking place. That, the high, steady flow of immigrants to the United States over the last decade and decades. Today, about the U.S. represents about 5% of the world's population, but about 20% of migrants who are living outside their countries live in the United States. We've seen, obviously, a steep rise in the unauthorized population, and, of course, we've seen, important for this issue, the dispersal of immigrants to non-traditional receiving states. And so we see these issues transformed from a six-state issue, which was the issue when many of us entered this field, to the 50-state issue that it now is. In the area of immigrant integration, I think the trend to devolution was really kicked off, to my mind, by welfare reform, the 1996 welfare reform law, which granted the states a power to discriminate in the provision of public benefits that they didn't have before. This was a change that gave rise, at least in my case, to a kind of a fear, which I think is as yet an unrealized fear, that there would be a race to the bottom. But beyond this question of immigrant integration and the devolution of immigrant integration policy, the story, if you will, of the last 5-6 years, even of the last decade, is the devolution of immigration policy to state and local governments. On the one hand, what we've got is Congress deputizing state and local government to enforce federal civil laws. And then at the same time, what we've got is the state and local governments themselves very much getting into the, if you will, the immigration sweepstakes, enacting laws that, as we're going to hear, both expand and curb legal immigrants' rights to employment, immigrants' rights to public benefits, to residence, to in-state tuition, and among other things. I think that understanding what is happening, understanding the unsettled state of the law here, understanding the implementation challenges, understanding the intended and the unintended consequences of this transformation is very important, if for no other reason, I think, then these state experiments with immigration and immigrant integration policy are going to shape what is viewed as doable, and they're going to shape what is viewed as desirable the next time we get into comprehensive immigration reform debates in earnest. I think if you only look at the Arizona mandatory verification law, that's going to have a big impact on upcoming debates. But there's a bunch of policy questions, obviously, in here that this panel will hopefully get to, or that may come up in questions. If welfare reform didn't do it, will punitive, if you will, state and local laws really kick off a race to the bottom in terms of public policy? Will we see the emergence of very differing climates of reception from state to state with differing integration trajectories, not just for unauthorized immigrants, but for other immigrant populations as well? Are we likely to see new patterns of discrimination emerge, not in employment and in housing? Or, if you want to view this devolution through rather a different lens, does the enrollment of state and local governments in immigration enforcement represent a very important force multiplier in the whole area of immigration policy? And does their enlistment basically represent a more or less logical evolution in regulatory authority along the lines that we've seen in occupational safety and health legislation or in antitrust legislation? And finally, does this expansion of state and local governments and the discomfort to which they're giving rise, discomfort among immigrants, among employers, among NGOs, among landlords, is this really in the end the goad that is needed to get people back to the table for comprehensive immigration reform? Okay, so we can discuss some of these policy issues and some of these theological issues later. Let me just introduce our panel. Our first speaker will be Cristina Rodriguez. Cristina is an associate professor of law at NYU Law School, where she's directed the Immigration Rights Clinic. She's a former Rhodes Scholar. She's a former clerk to U.S. Appeals Court Judge David Tatel, and she's a former clerk to U.S. Supreme Court Judge Sandra Day O'Connor. Our next speaker will be my colleague Muz Chishti, who directs New York MPI's NYU office, our office at NYU Law School. Muz is a former director of the Immigration Project of the Union, Needle Trades, Industrial, and Textile Employees Unite. He's a graduate of Cornell Law School and of Columbia School of International Affairs. And our final speaker will be Laura Varela. She's the project director of, for all of us, the very important Immigrant and Refugee Rights Project of the Washington Lawyers Committee for Civil Rights Under Law. Laura worked for CASA of Maryland previously and is a graduate of Michigan Law School. Cristina and Muz will start with some comments framing the national developments in this area, and then Laura will talk from her experience in terms of doing some litigation here in the Washington region. So with that, Cristina?
Thank you very much, Michael, and thanks to all of you for being here. So the idea that immigration is a federal responsibility, if not exclusively, then at least primarily, is something that's deeply rooted both in constitutional doctrine and in, I think, public understanding of how regulation has been and should be regulated. Now, the reality is that historically, states and localities have played a major role in regulating immigrant movement. And the trends since 2001 in particular have been striking. We heard some detail this morning about the extent of state and local activity in the last couple of years associated with regulating immigrants and immigration. And that activity, I think, provides us with an opportunity for some renewed consideration of what the role of state and local government should actually be when dealing with immigration as a phenomenon. So some would argue that the level of activity that we've seen in the last couple of years, in 2007, more than 1,000 bills were introduced in the state legislatures of the 50 states related to immigration in some capacity. 2008, the numbers appear already to have reached that level. Some people would say that this intense interest is the result of the federal government's failure to come up with comprehensive immigration reform that would address, in particular, the phenomenon of unauthorized immigration. And I think there is something to that failure thesis, that the federal government's inability to address the illegal phenomenon in particular is leading state legislators to feel like they must respond to their constituents' concerns. But I think that what's going on in the states is also reflective of something deeper than that, and that's the size of the wave of immigration that the United States is currently experiencing and the extent to which immigration actually implicates the interests of states and localities in a way that warrants state and local involvement on some level. So I think it's not sufficient to say that this is a federal responsibility exclusively, but that we do need to, given these trends, come to some kind of understanding of how states and localities can be said to participate. So what I want to do in the time that I have is talk a little bit about some of the things that states and localities have been doing. Muz and I, together with a research team at MPI and NYU, are doing a comprehensive cataloging of the measures that have been adopted between 2001 and 2008, and so have some familiarity with what's been happening across the country. And then to give you a brief sense of the legal framework for understanding, under current law, which of these measures test the limits of the authority of state and local governments and which might represent opportunities for collaboration and cooperation into the future. So instead of categorizing what states and localities have done according to a positive versus negative metric or a pro versus anti-immigrant metric, I think that the way that I would characterize it is to say that states and localities are doing one of two things. They're either attempting to abate the phenomenon of illegal immigration in particular through enforcement-oriented measures, or they've accepted the existence of immigrant populations, and whether or not it is understood to have a harmful consequence to have high levels of illegal immigration in particular, they've adopted measures that are intended to help integrate populations of immigrants and, importantly, to prevent exploitation of unauthorized populations or immigrants generally. One thing that's important, I think, that we've discovered in the research that we're doing to keep in mind is that these two different types of measures, you can loosely call them enforcement measures versus integration measures, have been introduced in every state legislature. In other words, there are legislators in every state that are interested in both types of strategies. And there are some states where the enforcement measures are more likely to pass than the integration measures and vice versa. But there's a great deal of internal ferment and diversity within the states themselves. That's one of the interesting phenomena that we've sort of uncovered in doing the research that we're doing. Now, I'll talk specifically about two of the enforcement measures and one of what we might call integration-oriented measures and give you a sense of the legal framework that surrounds them. And what I'll focus on will be the direct enforcement measures, including the involvement of state and local police in trying to deal with unlawful immigration, employment-based measures or cracking down on employers who hire unauthorized workers, and then the issue of granting in-state tuition or denying in-state tuition to unlawful immigrant students in particular states. The first two, because they are among the most popular of the measures that have been introduced in state legislatures. As the Senator mentioned this morning, ID-oriented laws are also quite popular in that they requirements that someone prove their citizenship or lawful permanent resident status to get benefits, or state legislators expressing opposition to the Real ID Act, which is also a very popular form of expression in state legislatures today. Those are also fairly common. But the ones that that have the greatest legal implications, that are the source of a lot of litigation that Muz is actually going to talk about, are these measures focused on direct enforcement and cracking down on employers. And then the in-state tuition issue is one that has an analog at the federal level with the DREAM Act, the Senator also invoked this morning, but is one that also tends to divide states in interesting ways, where states where you wouldn't expect people to be accommodating towards unauthorized immigration actually want to extend certain integrative benefits to children who, through no fault of their own, happen to not have lawful status. Among the other types of measures that are popular and have been popular include these anti-exploitation measures that I alluded to. In particular, measures that crack down on trafficking, on human trafficking, and provide services to victims of human trafficking, regardless of whether they have lawful status, as well as measures that regulate immigration service providers. These are also quite popular and tend to have a high passage rate because they go after people who present themselves as able to give legal advice when in fact they don't have the authority to give legal advice and therefore end up exploiting and taking money away from immigrants. So states are also cracking down on those. And so there's a broad range of things that states are doing. But I want to focus on the three in particular that I mentioned because of their salience in the debate. And there are two ways, I think, of thinking about these measures from a legal perspective, two ways of either challenging them or defending them. And the first strategy includes a preemption strategy, basically beginning with the argument that I started out with, that immigration is a federal responsibility and state efforts to regulate immigration, particularly engaging in immigration enforcement, are preempted by federal law. Now, this preemption strategy and the way that it's discussed in courts has strong constitutional underpinnings. The courts use a lot of constitutional rhetoric in saying that the Constitution assigns the authority to the federal government to regulate in the immigration context. But in reality, what almost all of these cases come down to is a question of whether a federal statute exists that is in conflict with the state law, or whether the state law that has been passed conflicts with an existing federal statutory scheme. And not to get overly legally technical, though this is one of my favorite areas of the law to teach, but there are three different kinds of preemption, and each of them is at stake in some way in this debate. There's the relatively straightforward type of law where the federal government has said no state may do X, and then clearly any state law that does X is preempted. But most of the action is in what's called implied preemption, whether the federal government has a law or a legal framework that when the states enter into that area, they then create a conflict with. So the federal government may not have explicitly said that a particular type of state law is invalid, but it has created a legal framework with which states theoretically are not supposed to interfere, and so the requirement is that there be demonstration that there be some kind of unwarranted interference. So that's the first type of legal argument that's made against a lot of what states and localities are doing that are based on this deep constitutional presumption of exclusivity, but that actually get into some very technical statutory questions that I think Muz will say a few things about. And then the second type of legal claim that has been, and in some cases less successfully been made against state and local activity, is the individual rights-oriented claim. Individual rights such as the protection of due process of law or the guarantee of equal protection of the law, and in some instances even the First Amendment free speech right, have been invoked as limitations on what states can do vis-a-vis immigration regulation and the regulation of immigrants through immigrant policy. In my mind, it's these individual rights concerns that are the true source of concern of those who find developments or trends in state legislatures troubling. Not so much that there's something inherently problematic about states becoming involved in immigration regulation, but that when they do so, they're more likely than the federal government to trample on important individual rights than the federal government. And I think that's a contestable assumption, but I think it's one that drives a lot of the preemption argumentation, and that much of the concern is really about these individual rights claims. Either that a lot of the enforcement-oriented measures that have been adopted by states are forms of discrimination, either because they're directly intended not just to stop unauthorized immigration, but to crack down on the growth of, say, the Latino population, that they're actually intended that way. There's kind of a cultural dimension to what's going on, or that in trying to abate illegal immigration, these measures actually have impacts on U.S. citizens and lawful permanent residents who are intertwined with those whom the laws directly target, and that raises equality concerns. And then there are also the due process concerns, that employers who are losing their business licenses or workers who are losing their jobs are not being given notice and the opportunity to be heard to contest the claim that's being made either by an employer or by the state that's prosecuting the case, that they're not entitled to hire X person or to lawfully work in the United States. So it has been the case, and Muz will say more about this since he's going to talk about the litigation, that it's actually been the preemption strategy that's been much more successful in court than the individual rights strategy, even though that's the primary source of concern. And so I want to say a little bit about how the preemption framework has worked or works in application to the three areas that I talked about. The first being direct enforcement, using state and local police to participate in the enforcement of immigration law. Now, as Michael alluded to, this has taken a number of different forms in the state laws that have been passed in the last couple of years. One of the most popular types of laws that gets introduced, though very few of these actually have been enacted, are those laws that would direct state and local police to enter into what are known as 287G agreements, or agreements with the federal government for state and local police to receive training from the federal government to participate in actual civil immigration enforcement, something states can't do of their own volition, but that according to a 1996 law, they now have the authority to do if they go through this particular legal channel. There was some ferment at the time that this was adopted, and still people making the argument today that this is inconsistent with the idea that states don't have authority to regulate in immigration and that it's exclusively a federal responsibility. And so the federal government can't devolve its authority as a constitutional matter to state and local police in this manner. Now, I think that debate largely has been one on the side of these agreements being permissible as a constitutional or legal matter. And the debate in that area is really about whether they actually make sense. And there are plenty of police chiefs and police themselves who are opposed to local police becoming involved in immigration enforcement because of the impact that that has on their ability to generate trust in immigrant communities. But that debate has moved largely out, I think, of the legal realm and into the policy and political realm. Similarly, with the other quite popular type of enforcement, direct enforcement measure, the type of measure that authorizes state and local police to ask people about their immigration status when they have them in custody. Usually the trigger is for a DUI, driving under the influence offense, or a felony. And so the way these work is that state and local police are directed when they have someone on one of these conditions to ask about their status. And if they indicate they don't have lawful status, the state and local police are directed to inform the Department of Homeland Security, or ICE, of the person who doesn't have status. Now, again, there's some concern that this is a kind of a backdoor around the presumption that state and local police can't enforce immigration on their own. But in reality, this type of measure is not all that distinct from what police generally can do, and that is ask people in their custody the questions, including questions about their lawful status. There certainly is the right of people not to answer those questions, as anyone would have when in a custodial situation. And there are questions about what state and local police can do with the information that they receive. But again, this is an issue that is largely, I think, out of the legal domain, except perhaps in as-applied particular cases, and more in the policy domain. The place where I think there's the most legal ferment and not just political policy debate is in the context where states are trying to indirectly enforce immigration laws, and that's through the types of employer sanctions provisions that states have passed. The most famous one is the one adopted by the state of Arizona. It's the one that I think is in the most advanced stage of litigation. Hazleton, Pennsylvania also has a similar type of ordinance, and these ordinances do a number of things. But the most important things that they do are one, they require employers who do business in the state to participate in the federal government's E-Verify program, to basically use the E-Verify or basic pilot database to verify the status of their workers. And the second thing they do is that, at least in Arizona, it's upon a second finding that someone has hired an unlawful worker, that business loses its license to do business in the state. So it's basically two strikes, and you no longer can keep your doors open in the state of Arizona if you're found to knowingly, and that's an important limitation, have hired an unlawful worker. And it's on this question, I think, of the revocation of business licenses where the fight really is. And Ms. will tell you about the state of the litigation. But the reason that there's a lot of fight going on here is because there's an explicit statutory provision that Congress adopted in 1986 in the Immigration Reform Control Act, in IRCA, that could be read to authorize precisely this type of state measure. It says that the employer sanctions scheme that Congress created in 1986 preempts any state or local laws imposing civil or criminal sanctions other than through licensing or similar laws. So you've had some states that have attempted to adopt laws that impose penalties, monetary penalties, civil or criminal fines on employers who hire unlawful workers. And many states' attorneys general and other legal experts have very clearly said that these are clearly preempted by this provision in IRCA. But what's not clearly preempted as a statutory matter is the use of the licensing authority to try to prevent employers from hiring unlawful workers. And so in some ways, the ball is really in Congress's court here, because there are courts that have read this provision to authorize what states like Arizona are doing. And so the debate, if you believe that that's true or accurate as a legal interpretation of the statute, is for Congress to resolve whether Congress actually wants or intended for states and localities to be using their licensing authority the way Arizona has been, or whether it creates immigration-related headaches for the federal government, for example, by by overtaxing the E-Verify database or imposing disuniform or non-uniform standards in the enforcement of immigration law, because you have states doing it according to one set of procedures and the federal government according to another. Though it's also important to note that all of the state laws that adopt this kind of position are very clear in adopting federal immigration standards in what they say. Okay, so Michael's looking at me like I should wrap this up, and I will. To say that, and maybe we could talk about in-state tuition in the question and answer period, that states, I think, are going to continue to be active regardless of whether comprehensive immigration reform passes or not, in large part because this immigration is an issue that is a source of concern with respect to the things that states traditionally regulate, such as health, safety, and welfare, public education in particular. And so in some ways, the ball really is in Congress's court to figure out a way to come up with a form of cooperation that eliminates the externalities that states are imposing on each other, and that eliminates interferences that states might be imposing on the federal government, but that allows states to exert some form of control over a phenomenon that is clearly of concern to their constituents. And so I'll leave it at that and turn it to Muz to tell you a little bit more about the actual state of play in the litigation on these issues.
Thank you. First of all, only an emanator Cristina can keep anyone talking about preemption alive at 2:30 in the afternoon.
I don't know if I succeeded in that.
I'll just do three things, mostly also in the interest of time. One is to just update on you the state of litigation on these various important state and local measures. Two is sort of very quickly highlight some of the important measures in the states that are coming up in 2008 as against 2007, which Cristina spent time talking about. And third, talk about executive orders, something that we don't normally pay attention to in the context of legislation. These are measures adopted by governors of states beyond the legislation that these state legislatures adopt. First, on litigation. I mean, there are a lot of litigations going around, as you can imagine, all around on this issue, but I'll highlight only 4 cases. First, Hazleton has to be the mother of all cases on the issue of preemption. For obvious reason, it attracted the public imagination. There was a larger-than-life mayor of Hazleton called Lou Barletta, who made his career appearing on Lou Dobbs every third night, you could imagine. There was an 85-year-old judge who wrote an extremely long, voluminous opinion. Most of it is written for history and in quotable quotes, and as I'm sure all of you advocates are busy quoting Judge Munley in all of your advocacy material on this issue. But most importantly, Hazleton is important because it's the only case that has gone to full trial. So for all that reason, Hazleton needs, obviously, some attention. In July of 2007, Judge Munley essentially enjoined the enforcement of all ordinances in Hazleton, and basically, I think, said 4 things. That these are, as Cristina pointed out, these are ordinances which would penalize employers for hiring undocumented workers and deprive them from getting business permits if they do that. And then it would penalize landlords from renting to undocumented people. And the federal district court opinion in Hazleton said that these provisions were preempted both under the express and the implied preemption doctrine that Cristina just laid out for us. He also found that the housing provision was preempted expressly by federal law, and that both the housing and the employment-based provisions violate the 14th Amendment's due process protection, and also hinted that as applied, they could also violate the equal protection guarantees of the 14th Amendment. And he also found out that they also violate the person's right to enter into a contract. Now, this is a very long, important opinion. It's obviously an appeal to the Third Circuit, and they've been fully briefed. I actually talked to the ACLU lawyers who are litigating the case. No date for the argument has been set. The Third Circuit is known actually for taking its due time. We expect an argument on that case will happen sometime in the fall or winter. The prognosis on Hazleton, obviously, with each of these things, we never know. But I think the litigators feel strongly that they have an extremely strongly worded opinion by a federal district court judge, and that the record, because it's the only case that has gone to trial, that the record in the case is strong for them to feel good about the case. Now, contrast Hazleton to Arizona, which is the other main opinion that has gone in the last year or so. In the Arizona case, it affects, as Cristina pointed out, two things. First of all, in the first instance, when an employer is found hiring an undocumented worker, your license is suspended to do business. If you're found violating it twice, your license is revoked. This is why Governor Janet Napolitano called it the death sentence for employers. And the second thing it does is it requires all employers to use E-Verify to screen all new hires after January 1st of 2008. The arguments by the ACLU and others against the Arizona law is that it is preempted by the federal law. It violates due process protections, it interferes with interstate commerce, and it violates Arizona's Constitution. And the Federal District Court in February of this year essentially disagreed with all these 4 points, and all 4 points held for the defendants. Now, this is where I think what Judge Munley didn't do in Hazleton case, Judge Wake did in the Arizona case. He brought to life the unspoken 7 words in our preemption statute that Cristina referred to life. And here I think, some of you were around in '86, and I feel personally actually somewhat embarrassed about it. I lobbied the '86 law. None of us remember how those 7 parenthetical words got into the statute. Again, a lesson for all of you young lobbyists and young law students here is that every word of the statute counts. These are written in parentheses, and they're almost an exception to the overall preemption rule of the statute. And Judge Wake said, essentially, that statute is what the language says it is. Don't tell me any ancillary, any other stuff of legislative history that you want to point out to me. Congress meant what it said. It has allowed states to have leeway in having employer sanctions law through licensing. That's what Arizona has done, and he upheld it on that basis. That's obviously on appeal. It's an expedited appeal, and the argument, they've been fully briefed. The argument is scheduled for June 12th in San Francisco. Prognosis, again, who knows? Ninth Circuit is a particularly unpredictable circuit on these issues. I think, obviously, the judgment in this case, I think Cristina is more of a scholar than I am, thinks that if Judge Munley's opinion is a Russian novel, Judge Wake's opinion is a button-down version of straight law. And it's very hard to find holes in that opinion. I think it's a very difficult case for the plaintiffs to win on appeal, but we could all be surprised. Since the case has gone on appeal, there was recently an amendment to the Arizona statute signed by the legislature there, and this makes many important changes. But one important change it makes is that it doesn't mandate that every time someone brings a complaint on the basis of this violation of the law, that the county lawyers have to enforce it. It leaves it to the discretion of the county lawyers. So therefore, what actual effect this law will have now is, frankly, much more of a guess than it was, a few months ago. The third case that is important to watch is the case in Valley Park, Missouri. The Valley Park, Missouri started with 2 issues. One was, again, a landlord-tenant ordinance, and the other was employer ordinance. The landlord-tenant ordinance was actually repealed. So at the end of the day, only the employer-related ordinance went to litigation. And the employer-related ordinances basically says that anyone who applies for a business permit in the state of Missouri must sign an affidavit that it will not use the services of an unauthorized worker for work. And someone can complain about these things. Both the Arizona and the Missouri law, they're all complaint-driven. That means ordinary citizens can call in saying that employer is hiring undocumented workers, and then someone in the government has to investigate that. An extremely important and I think pernicious development in our law. And if under the Missouri law, under Valley Park law, if someone is giving notification of the violation, they must have 3 days to correct it. If they don't, then they'll lose their license. Federal District Court again in January of this year upheld the ordinance. It's again on appeal to the 8th Circuit. It's just rolling in. No briefings on that case have happened. The fourth case to follow is our favorite case in Farmers Branch in Texas. We heard a little bit from the distinguished senator from Texas this morning. It's a very strange case, and I find it I think it has a procedurally both murky and its evolution rather awkward. Farmers Branch is a city outside Dallas, which last year made it unlawful for landlords to rent to undocumented people and asked them to check for the status of people before they rent. And that was enjoined. There was a TRO issued and then a permanent injunction in May of 2007. And essentially, we believe that the city almost gave up on the litigation. But then suddenly, early this year, the city reintroduced an ordinance. And again, using the 7 favorite words in the parentheses, this time they introduced as a licensing ordinance that you need a license to rent an apartment. Therefore, again, invoking the license exception in the preemption statute to justify something that they had been enjoined from doing only last year. Now, whether that's significant difference or no, I think is going to be very important to watch in litigation. I think as a very strange compromise, the state legislature said that the city legislature said they were not going to enforce this ordinance until the original case, which is still under appeal, is going to be decided. These are, I think, the 4 cases. There are obviously other important cases which are in the state court, which are going through. Very important case in Arizona challenging the Cave Creek anti-solicitation ordinance recently. I think the one to watch is Georgia. We had a big omnibus bill. Georgia actually agreed that they will keep on hold their law until the Hazleton and the Valley Park case were finally concluded through various sessions of appeal. So obviously that is something to be watched. 2008 measures. A lot of things are happening in 2008. I would urge that we look at 3 major developments in state that I think are worthy of mention. First is Mississippi. I didn't even know this had happened. I mean, it's happening at lightning speed and a landslide margin. That state of Mississippi passed 2 very important laws. And was, I think, in the Senate, it passed by 52-0, in the House by 112-8, and the Governor Holly Barber signed it in no time. It first of all asked all employers in the state to use the E-Verify. It provides a staggered term. You have to begin in July of 2008. By July of 2011, all employers have to use E-Verify. And if you're found guilty of hiring undocumented, you lose license for 1 year, and you lose state contracts provisions for 3 years. The second most important part of this law, which again I think none of us had heard of till recently, it criminalizes work by undocumented people. That if a worker is found to work illegally, he is fined $10,000 and could face a prison term of 1 year. Now, so obviously this is breach and totally what Sensenbrenner could not accomplish in the House bill. The state of Mississippi has obviously done through its litigation. What's most interesting about this, no litigation is contemplated on this so far. I think people are so scared of challenging this in Mississippi that I haven't heard of any litigation so far. The second quickly is Missouri. Missouri passed is debating didn't pass a very important omnibus bill on employer sanctions, on E-Verify, public benefit screening, on police being asked to question everyone they arrest about their status. Both houses have passed them, but they haven't reconciled the 2 bills, which I think makes a lot of observers wonder whether this is more a posturing and an election year politicking. The last state to watch is South Carolina. South Carolina, a lot of people argue, has become the new ground zero after Arizona of these measures. There was actually a compromise negotiated by employers in South Carolina which they thought they could live with. And under this will be the new trend, that instead of employers being asked to use the E-Verify, they'll be asked to use something called the South Carolina Verify, which gives them the option of using the I-9 form, and the I-9 forms could be randomly audited, and they would get much more robust fines. I think the House and the compromise is not working out. The two houses haven't reconciled. Governor Mark Sanford is being much more sort of aggressive than the Senate and the House in asking they need tougher employer sanctions law. I think, consistent with what Cristina said in her analysis, the interesting thing about South Carolina is that it doesn't invoke the license law. It doesn't say you'll lose license. It just says you'll be fined heavily, which I think would probably both of us would agree is much more subject to challenge than the Arizona and the Valley Park laws. The last point I want to make is very quickly, is for us to watch the phenomenon of executive orders. We pay a lot of attention to state legislatures because that's where the action is. But suddenly, governors are issuing executive orders with a very important import. The four to mention are the governor of Arizona, Napolitano's executive order in 2007, which sort of amends the mandate of the Arizona-Mexico Commission, which is located in her executive office, which sort of asked Mexico to engage in bilateral negotiations with the state of Arizona to monitor the border and also improve some economic development issues between Mexico and Arizona. The two other orders, and I'll combine them quickly, one is in Massachusetts signed by Governor Deval Patrick, and the other in Missouri signed by Matt Blunt. They both are about employer sanctions, and they want to ensure that employers who use state contracts will only hire authorized workers. And the last of 2007 executive orders is signed by Governor Corzine of New Jersey, which is actually a positive one. He appointed a blue ribbon commission which would make recommendations for integration policies in the state of New Jersey. In 2008, to conclude, there is actually a very important executive order to note, which is in Rhode Island. The governor of Rhode Island has suddenly become much more active and much more engaged than the legislature of Rhode Island, which itself is quite engaged. And the executive order issued, I think, in March of this year by Governor Corseri, I think his name is Corseri, which does two things. It first of all states that any employer who uses state contracts cannot hire an unauthorized worker and must apply through E-Verify. And it mandates that all the local state police, the state police and correctional facilities enter into 287G agreements to help the federal government enforce immigration law. Obviously, it's gone into effect. Very important new trends to watch for all of us. Thank you.
Thank you, Moose. Laura, we've all gone on too long, so we've robbed you of your time. So maybe you could try to keep it to 10 minutes so we get questions.
Okay,
Thanks.
will do. I really just wanted to talk about the practical realities when you try to bring a lawsuit in federal court, especially when you're dealing with plaintiffs who might not be documented, plaintiffs who have temporary protection status, plaintiffs that are LPRs but are afraid that if they rock the boat, if they file in federal court, what happens? What's going to happen to my papers? Are they going to take my papers away? I'll start first with the lawsuit we filed against the city of Manassas. For about 3 years, the city of Manassas was trying to think up ways to try to rid their city of primarily Hispanic residents. They did this by playing with the zoning ordinances, and finally in 2005 they decided what they had to do was actually change the definition of family in the zoning ordinance, because what they found the 3 years prior was they were going to these homes, but they were all family members because a lot of the Hispanic families live with aunt, uncles, niece, and nephews. So they decided to change the definition of family to make it a nuclear family. You could only live with your nuclear family and perhaps one additional unrelated tenant. In 2006, they changed the definition of family. We wrote some fairly substantial, nasty letters to the city of Manassas, and they rescinded the definition within a month. They realized what they had done. We filled the letter with the violations of Supreme Court law and other laws. But at the meantime, we thought we would go ahead and FOIA the city of Manassas, and what we found was over a period of 8 years, the city of Manassas had selectively enforced already their zoning ordinance, and what we found was 99% of the inspections were were in homes where Latino families lived, although the percentage of Hispanic residents in the city of Manassas is only 20%. What we also found, interestingly enough, were emails from the zoning office to the school officials, and again emails from school officials to the zoning office saying, I've got multiple families living at a certain address. You should go inspect this address at 9212 Crandall because we have a Rodriguez and a Varela living there. You should go inspect it. And the inspectors actually listened to the school officials. School officials violated federal and state law, all really just to rid the city of Hispanic residents. Finding the plaintiffs. It took 2 years to really find and locate the plaintiffs. We had the FOIA documents, we had names, we had addresses, but we went to these addresses. I don't know how many doors I knocked on, together with some investigators and outreach coordinators. We knocked in at least 80% of the names and homes and addresses that were actually released to the zoning offices. No one lived there anymore. They were gone. They were inspected. The inspector came in and it told them they were in violation of the law, and if they don't get out of their home, or if they continue with the zoning ordinance or violation, that they will be evicted or they will be arrested. So that was very difficult. At the end of the day, we actually did find 18 plaintiffs after 2 years. 7 of them were too afraid to pursue federal litigation. Even though a lot of them were LPRs, a lot of them had temporary protection status because simply they didn't want ICE looking into their records. They didn't want the federal government looking into their families' records. And we had a lot of residents who actually owned their own home, but it just so happened that their spouse did not file a TPS in time, did not file a TPS application in time, and thus he was or she was undocumented. And for that reason, these families lost their homes. These families had to evict sons who were over 18 years old. They had to evict aunts, uncles, grandmothers, and they did not want to engage in federal litigation for fear of retaliation. We filed that lawsuit in October of last year, which brings me to kind of another difficulty that we're seeing is filing in the Eastern District of Virginia. Judge Ellis, in a motion to dismiss hearing, I would say that my co-counsel was able to get out 2 words in response to the defendant's argument. The 2 words were, Your Honor. Judge Ellis, I'm telling you, spoke for about 45 minutes about, isn't this case really just about illegal aliens overcrowding homes and apartments and parking on the lawn? All the city is trying to do is regulate and make sure that these immigrants are safe. I mean, he spoke for about 45 minutes about his experience with illegal aliens and illegal aliens killing students in school on a school bus. I mean, he really did. I wish I had the transcript here with me. So again, that's another practical challenge that we're seeing is in the Eastern District of Virginia. Is the judges at the Eastern District of Virginia. Moving on quickly to the Prince William County lawsuit, I'm sure anyone who lives in the area was very aware, you couldn't miss it, the coverage on the Prince William County resolution that was passed in July of last year. The resolution basically stated that they authorized all county employees to inquire into the immigration status of anyone that seeks to use their services. Well, it was a resolution. It basically had no teeth, but the immigrants that lived in Prince William County left the county the second that resolution was passed. They left because they didn't know what it meant. They were under the impression that their kids that went to the school, the school is run by the county. That means the employees can ask the kids about their immigration status. They can ask the parents about their immigration status. People that need food stamps for their children who are U.S. citizens. They were afraid. They didn't know what the ramifications were of the resolution. They didn't know what it meant, and they left. They sprinted out of the county. In the end, they actually decided that all county services could not, all county employees could not actually look into the immigration status of anyone who tries to use their services. But they did, in the end, still authorize the Prince William County Police to look into the immigration status of anyone who they stopped, even if only briefly. And explicitly in the police orders said you could actually use national origin as a reason for asking one's immigration status. So we filed in October and for injunctive and declaratory relief as well as equal protection claims, and Judge Kacharis held on to standing. We had 22 plaintiffs. Two were U.S. citizens. Several were LPRs. We had several that had temporary protection status, and a few undocumented and children. Arguing that business owners had already lost business. Many LPRs, many TPS folks had an actual fear of getting pulled over, because someone who has TPS, really the only thing they have that shows that they are in the country legally is a work authorization card. And work authorization cards, they expire. And a lot of clients that we had, their work authorization cards had expired 6 months prior. But even the immigration regulations state, even if your work authorization card expires, you will get a new one within 6 months to a year. But that meant that they were driving around with work authorization cards that had already expired, so they actually feared that they would be unlawfully detained. Nevertheless, Judge Kacharis didn't buy any of our arguments in our 80-page brief and decided that none of our plaintiffs had standing. We are currently investigating several complaints that have come in recently and hope to refile sometime very soon.
Super. Thank you. Questions? We have 5 minutes for questions. Okay, go ahead.
I have a question for Laura. I'm interested in what your causes of action are, especially in the first case, the zoning case. On what are the arguments that you're making?
Primarily violation of the Fair Labor Standards Act, violation of the Fair Housing Act, equal protection, due process violations as well, and violation of the Virginia Housing Code and the Virginia Constitution.
On the equal protection claim, what sort of evidence do you have? We have statements from council members who were on the actual task force that was charged with enforcing the law, who knew that several white American Anglo families were in violation, and the officials, the director of the task force, explicitly said, we are not going to inspect those homes. And we have his affidavit and declaration, and several others who were on that task force, who eventually stepped down from the task force when the definition of family was changed in 2005.
I have a question, too. As the economy turns down and it seems public assistance use is going up, is there much legislative action in that area? I noticed the governor of California recently announced that he was going to try to restrict the grant of Medi-Cal to legal immigrants who've been in the country for less than 5 years.
There is a lot of public benefits-oriented legislation. Most of it is of the ID variety, because the federal law sets a floor on what states must. They can't deny emergency services, for example. So in some state legislatures, those kinds of bills have been introduced but haven't passed because it's obviously in conflict with federal law. But through identification requirements, it's one way of trying to crack down. And then there's some freedom for states to set their policy in the in Medicaid, with different aspects of Medicaid, because it's a joint federal-state program, and there's actually a fairly complex body of law that governs what states can and can't do. And so it's quite possible that Schwarzenegger is within the authority that he has to do that. And there has been some litigation where courts have come out in different ways, where the Supreme Court of Maryland and the Supreme Court, or I should say the Court of Appeals of the state of New York, have said that in instances where the state theoretically claiming, or not even theoretically, actually claiming the authority that federal law gives them to determine eligibility, to cut off lawful permanent residents or other qualified aliens from benefits, actually have overstepped their bounds, and the federal government doesn't have the authority to allow states to do what would otherwise be a violation of the Equal Protection Clause. And there are other courts that have come out differently. So the legal landscape there is not 100% clear, but the Maryland case is from just last year, and the New York case is, I think, from 2005. So I suspect if things like this continue to happen, as there's more and more concern about public benefits claiming, that you'll see more of those lawsuits.
Any further questions? Besides the panelists' own questions? Okay.
I had a quick question for Laura. I'm wondering if you've filed any lawsuits on behalf of detainees who are in state custody, but they're being held on an ICE detainer and they're being held for longer than 48 hours?
We have heard several complaints, again going back to the challenges of people that have been held anywhere from 3 months to a year beyond the date that they were supposed to be released because they're on the ICE hold in county facilities. We're investigating claims right now. Again, it is very challenging. We're working with the CARE Coalition since they're going to these facilities on a regular basis, trying to find people who have been detained longer than 48 hours.
Great. Okay, I would just make you aware of two things. First, Moose and Cristina have written an absolutely terrific paper called Testing the Limits, in which they go and explore these issues and in these legal issues in a totally accessible manner. And if we haven't sold out outside, it's downloadable on our website. And second, you should watch our website for future coming attractions, because we'll be launching the database of state ordinances very soon. And with that, I'd like to thank the panel for an absolutely terrific job. And thank you.